I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. The Supreme Court has ordered Congress to submit detailed information on the impeachment proceedings against Vice President Sara Duterte. This amid several petitions calling for the dismissal of the case. Could the High Court's directive delay the impeachment trial once more? Let's get on point with retired Supreme Court Senior Associate Justice Antonio Carpio. Justice Carpio, good to see you again. Thank you so much for your time. I know the traffic was horrible. I said the traffic was horrible, wasn't it?
Yes, horrible.
Very bad. All right. So let me start with this. It was a resolution last July 8 wherein the Supreme Court had actually ordered the House or Congress to file under oath information or even details in relation to the petitions filed by the camp of Vice President Sara Duterte in relation to the impeachment case that was filed against her. From my understanding, the petitions, there are two petitions filed by the camp of the Vice President, which the Supreme Court consolidated. What I want to find out, I guess, just to start this off, is an overview of two things, Justice. I hope you don't mind. I want to talk about the timing of this resolution last July 8, or a little over 2 weeks before the 20th Congress begins. The two petitions that were filed by the Vice President, just for context, were filed last February. 5 months later, the Supreme Court says, I need more information from the House of Representatives regarding this impeachment case. What do you say about the timing of this, considering that in 2 weeks or more, mag-uumpisa na po yung 20th Congress?
Well, I think my sense here is that when the petitions were filed, as you said, in February, the thinking then was that because of what the House Secretary General told everybody, that he was asked to delay, and that everybody thought that the 10 session day period had lapsed. And I think, but when the House submitted its reply, Sara's answer before the impeachment court, it turned out that the 10 session day period was not breached. That on the 10th session day, the fourth complaint, which had the signature of more than a third of the members of the House, was submitted to the Secretary General. And I think that was not in the records of the court. That's why they asked for that. That because that was something new, and it was reported in the papers. So they asked for that because they could not decide the case unless that is settled. Because here is now the House telling the impeachment court that the 10 session day period was not breached. But I think that information was not in the Supreme Court. That's why they asked for it. Mm-hmm. That's my reading.
But that's among other things that they asked,
yes.
Justice. No, but I want to go to that a little later on. But I want to go back to my question. It's the timing, because you've been there, and I guess the point is, July 28 is the State of the Nation address of the President. July 29, it is expected that the impeachment trial will begin, or, Justice, that it will be questioned by some senators, that the 20th Congress might not have jurisdiction. So it can actually begin, or it can actually be dismissed. I mean, I think those are the two things that might happen on July 29. So I'm just curious about the timing. Why ask the House now? Couldn't it have been done much earlier so that there could be some sort of decision, possibly, regarding this?
Yes, it could have been done earlier, but I think they asked for those, they sent that resolution asking those questions because I think they want to come out with a decision before the 29th, before July 29th. And
That's what I wanted to find out. Is that what you think? Is that because
yes, because
possibly?
otherwise, the Senate, as an impeachment court, will have to decide whether to proceed or not.
Right.
Out of deference to the Supreme Court, that the issue is there with the Supreme Court. So I think there's urgency for the court to act on it, so the impeachment court can be properly guided. I mean, that should be the case.
So you think a decision will be made before July 28 or July 29?
For me, it's most likely.
All right. Why? Again, because just to go back, the resolution was received by the House July 8, and they were supposed to answer within 10 non-extendable days, which would probably be July 18.
Yeah.
And then from that time on, you are presupposing that there will be a decision thereafter before Congress begins the 20th Congress.
Yes. I think the court or whoever is the ponente might be ready with the decision, but then this came out that the 10-session day period was not breached per the House, per the reply of the House. So they want to get confirmation. What exactly happened?
Yeah.
Was it breached or not?
Yeah. Was it violated?
Yes.
Or was it not violated? All right. It's okay. Let's do this. The second part that I wanted to ask is that some were saying that there were too many details that the Supreme Court had asked the House to actually respond to the point that I think it was an interview on radio by Congresswoman Laila De Lima, where she actually said that there could have been a judicial overreach. That's what I want to understand. Justice, were there too many questions that were asked by the Supreme Court to the House? Or is the Supreme Court well within its right, its responsibility to ask these questions?
Well, let's focus on one particular question where the Supreme Court said or asked that did those who signed the resolution, did they peruse the resolution? Did they peruse the charges? Did they peruse the charges and the evidence before signing? Well, we never ask the Supreme Court, whenever they come out with a decision resolution, whether those who signed the decision resolution perused the charges and went over the evidence. I mean, that's considered. If you sign it, that means you have studied it.
So you don't agree that they asked that?
Yes, I think I would agree it's an overreach. Because what's the point?
Okay.
They already, they signed and it's verified because there's a verification at the end that they read it and the allegations are true of their own personal knowledge or based on authentic records. Mm-hmm. I mean, you state that under oath. That should be enough already.
Even if, for the sake of argument, they didn't, for example, sir?
Well, there is such a thing as conclusive presumption because if you go into that, then we will never, you will have to ask every congressman who signed the bill whether, did you really read the bill? I mean, there is such a thing as an enrolled bill. Mm. The enrolled bill doctrine, once it's certified by the Senate President and the Secretary of the Senate and the Speaker of the House and the Secretary of the House, that's conclusive. I mean, you have to take it for what it says there.
Mm. Take it at face value.
Yeah, you take it at face value.
Yeah.
You can only question it if there is a breach of the Constitution. Like, you count the number of votes, kulang. I mean, if the Constitution says it requires 2/3 vote and you did not reach the 2/3 vote, you can question. Mm-hmm. But you cannot question those who signed. Did you read it? Did you understand what you were signing? I mean, that is supposed to be conclusively understood already by those who signed. We don't ask, for example, the president if he signs executive order. Mr.
Binasa
President,
mo ba
did you read that before you signed it? Did you understand it? No,
If
that's
that
a public
But if
document.
that is your position rather, Justice Carpio, why do you think this was asked?
I really don't know. I hope they will not, whatever is the answer, they should just take full faith, give full faith and credit to the document itself, that they signed it, they verified under oath that they read it, that it's that the allegations there are true of their personal knowledge or based on authentic documents. They should take it at face value because that's an official record.
Do you think that if you say that, then I am one to believe that you would say that the senators or the senator judges also will not have the right to ask the congressmen who signed this impeachment complaint if they really read it, if they perused through it, and if they knew exactly what they were reading?
Yes, they shouldn't ask that anymore. If there are defects, like for example, was there really at least a third of them, a third of the members of the House, they can question those things. Was it really filed on the 10th session day? They can question those things. But to question the members of the House, did you read what you signed? I mean, I think that's I would agree it's overreach.
All right. So it's about 3 pages, this resolution coming from the Supreme Court. Let's look into some of those, although we did discuss some of them already. I want to go to letter D. Let's put that up on air. Basically, it says, kasi yung pong sinabi ng Korte Suprema dito, merong A, B, C, D, E, F, G, H, I, J, K. These were the contents, no, Justice. So let me go to letter D. As to the complaints filed by the private citizens, the basis and authority of the Secretary General to refuse the transmittal of the complaints for impeachment to the Speaker of the House of Representatives for inclusion in the order of business within 10 session days from the time it was properly endorsed by a member of the House of Representatives. Just to recall, this was what you were talking about a while ago. And also, for purposes of clarity, this is part of the 1987 Constitution, wherein once an impeachment complaint is filed, it must be included in the order of business within 10 session days. Dito po nanggagaling yung letter D ng Supreme Court.
Well, what is in the Constitution is that the impeachment complaint must be included in the order of business within 10 session days. It does not, the Constitution doesn't mention that the Secretary General must submit it immediately to the Speaker. So that's in the House rules, but that's not in the Constitution. So the Constitution is concerned whether the impeachment complaint was included in the order of business within 10 session days.
Right.
And per the reply of the House to the Senate, to the answer of VP Sara, they said yes, it was included in the order of business
Within
the 10th session day. Yeah. And on the 10th session day, the resolution by at least a third of the members of the House was also submitted to the Secretary General. And under another provision of the Constitution, if a third of the member, at least a third of the members of member of the House adopt a resolution, that resolution becomes the articles of impeachment and will be transmitted
to the
Senate, and the Senate shall forthwith proceed with the trial.
Yeah.
So, and that's exactly what happened. On the 10th day, at least a third of the members of the House adopted that resolution. So that resolution supersedes the first 3 impeachment complaints because it's within the 10 session days. And that becomes now, the Constitution says, and shall constitute the articles of impeachment. So that is now the articles of impeachment that will be transmitted to the Senate, and the Senate, after receiving it, shall conduct its trial
forthwith. Yeah.
Yeah.
Another question on the forthwith,
Yeah,
which
that's still pending in the Supreme
yeah,
Court.
which I'll get to that also later. Here's a question before we go on a break, sir. I did speak to some of the House prosecutors recently, well, not very recent, maybe about 2 weeks ago, and I asked them about that, the 10 session days. I distinctly remember Congresswoman Bell Zamora saying that we have been wanting to be asked that question with regards to the 10 session days. And they were saying, we confirm that it was well within the 10 session days, meaning the first impeachment complaint was filed December 2. The second impeachment complaint was filed December 4. The third impeachment complaint was filed December 19. And the fourth one, that constituted the articles of impeachment, was filed February 5. To so many people, paano naman naging 10 session days yung December 2 from the time the first impeachment complaint was filed to December 5, that day, February 5, the day that it was transmitted to the Senate. They were saying that how they explained it to me was that there are only 3 session days. Wala pa po yung mga bakasyon. Monday, Tuesday, Wednesday. Kapag Monday daw, nag-suspend kayo, that does not constitute session day. Second day, Tuesday, nag-suspend na naman sila, hindi na naman daw session day yan. So ganun pala yon. So they say, we were well within the 10 session days. My question is this, Justice, what if there's another congressman who will actually say, no, that's not true. I count 12 days or 13 days or 14 days. What happens?
Well, that will be decided by the Supreme Court. Because that's a constitutional interpretation of the Constitution. What is the meaning of 10 session days? Well, we all know that during Christmas, December, they are not in session every day. And you can see their calendar. It's there in their calendar. They adopt that before every Congress. They adopt the calendar. You just look at the calendar. Now, what you cannot see there is if they did not hold the session on that day, the one that you were referring. But you can count there in the for the public can access that.
But I can imagine, I guess what I'm thinking is that if the pro-impeachment people say we were well within the 10 session days, there will be anti-impeachment who will say, hindi eh. Umover tayo dun sa 10 session days.
Well, if there is any difference, it will be accounted for whether it's a session day but they did not meet. Is that counted?
It's a session day, but there was no quorum.
There was no quorum. Then it goes now to the Supreme Court. Will you count that? It's up to the Supreme Court.
We'll continue our discussion with former Senior Associate Justice Antonio Carpio when we return. Stay tuned. This is On Point. Welcome back. Still with us, retired Supreme Court Senior Associate Justice Antonio Carpio. Another one I wanted to discuss is the letter E of this resolution. I'm going to read it, Justice. As to the complaints filed by the private citizens, and regardless of the legal positions of the respondents, the number of session days that lapsed from the time the complaints were properly endorsed by a member of the House of Representatives to its transmittal to the Speaker of the House of Representatives and its inclusion in the order of business. It's pretty much the same as what we were discussing a while ago. The next one is letter J. As to the articles of impeachment transmitted to the Senate, whether each of the members of the House of Representatives, ito po yung pinag-uusapan natin kanina, had time to peruse the charges and the evidence before affixing their consent. To that, it follows this. As to the articles of impeachment transmitted to the Senate, when it was included in the order of business of the House of Representatives for consideration by the entire plenary. All right, so that at least you have already, we had some sort of a discussion about that already. You're not in agreement with that?
Well, because there is already a verification under oath that the allegations there are true of their own personal knowledge or based on authentic document. That should suffice. That's sufficient because that appears in every petition in a court. That's verified. That's the form. that you're saying under oath that the allegations are true of your own personal knowledge or based on authentic document. I mean, that should be sufficient.
All right.
I mean, that answers that question already.
Okay. Can or should the Senate pursue the impeachment case in the 20th Congress, even if there's still no decision by the Supreme Court, sir?
Well, if there is no temporary restraining order, they should continue because that's their duty. And the Supreme Court, if they want it to stop, they should issue a TRO. That's the meaning of that.
And that can happen. A TRO can be issued even
Anytime.
even after this resolution, even after
No,
you sagot
after the
unang-
resolution, after the decision, that's final already. But before the decision of the court, they can issue a TRO.
Interesting here is other motions before the Supreme Court, sir. There's a motion on how to actually understand or interpret forthwith, which you were mentioning a while ago. Once the articles of impeachment reaches the Senate shall proceed with trial forthwith. Why was there a resolution on the questioning the legality of the impeachment complaint filed by the camp of the Vice President, when there's also a question on what does forthwith mean, questioning the Senate's supposed non-action after the articles of impeachment were transmitted to them last February 5?
Well, I think there's a taxpayer who brought it to the Supreme Court, asking the Supreme Court to define the meaning of forthwith. And that has not been resolved yet, and I think that will be decided at the same time with this issue on the 10 session days. So we'll have clarity after the resolution comes out.
Actually, yes, that's what I wanted to get more information. Whatever happens or whatever the decision of the Supreme Court will be, definitely there will be clarity on forthwith. The Senate shall hear and try all impeachment cases. 10 session days, hindi ho ba? All that will be able to have clarity, and in the next, whether there's another impeachment complaint or not, wala na pong questions on session days, forthwith, etc.
Well, remember, Pinky, that as you said, the first impeachment complaint was filed sometime in February.
December 2, sir.
December 2, I'm sorry. December 2. And we are now July. I think if there are no more oral arguments, there will be a decision. So by December 2, the 1 year period will lapse already. So the new Congress, the new House of Representatives of the 20th Congress, can refile the same articles of impeachment.
Right.
And the Senate will have to proceed with the trial based on the decision of the Supreme Court on the meaning of forthwith and on the 10 session days.
But is there also a possibility, Justice, after the Supreme Court issued this resolution asking for clarification from the House, that they will say that there is separation of powers here and that this is a function of the legislature and not the judiciary, hence no decision can be made? Is that also a possibility?
Well, it's possible, but I think because there is an issue on the meaning of forthwith and on the meaning of the 10 session days, whether the 10 session days include session days that were canceled or where there was no quorum.
So you think that there will be a decision?
Yes, I think
here?
the Supreme Court will make a decision because we want to put clarity, and I hope that they will decide this. Either way, if let's say that they will say that the 10 session days lapsed already when the more than one third of the House came out with that fourth complaint, then they will just wait for December 2 and then refile it. So the trial will still proceed. But we have clarity. And we've waited this long already. We're already end of July, almost end of July, and then you have August, September. I think we can wait. I don't see why we should be hurrying this.
There's also an issue, of course, Justice, that has been talked about many times, even before the Senate impeachment court returned the articles of impeachment to the House and asked for 2 certifications from the House. The first one being that they did not violate the 1-year bar rule, and that the second one was that the 20th Congress was willing to pursue what the 19th Congress has done. However, so far, from at least what I know, only 1 certification has been forwarded to the impeachment court. The second one, from my understanding, Sir, wala pa, that the 20th Congress is willing to.
Yeah. Well, I don't think that will be difficult because they have to wait for the election of the Speaker, because the Speaker will have to decide on the people who will form the new prosecution team. And it's normal that since this is a new House, a new Congress, the authority of the prosecutors to represent the House should be renewed.
Okay.
So that
anything wrong
comes
with
as
that?
a matter of course.
But what about the first certification that the Senate
That has been submitted already.
Right. What did you think of that? Was that necessary?
Well, it's up to the Senate now to if they want to go deeper into that, if they don't believe it, then they can summon the Secretary General, summon the records.
And isn't it also important, I guess, Justice, now that once a decision is made by the Supreme Court, that there will be a lot of clarity with regards to how long an impeachment complaint can actually stay at the desk of the Secretary General? Because in many interviews in the past, he was saying that he has not transmitted it to the Speaker kasi nakikiusap pa po yung ibang congressman na pag-aaralan pa nila or baka magkaroon pa ng isa pang filing, which actually happened Feb 5.
Yeah. Well, remember that the main requirement is that the impeachment complaint must be included in the order of business within 10 session days. But the House rule says that House rules state that the Secretary General shall transmit to the Speaker immediately.
May immediately po sila doon.
But immediately should be taken in the context of the 10 session days. So para humabol, so that it will not breach.
To complement the 10 session days.
So,
okay.
And the SecGen, per the certification of the House, transmitted it to the Speaker, who included it on the 10th session day. So, if you look at the rationale behind the immediate, that the SecGen shall refer the impeachment complaint to the Speaker immediately. That is the meaning, so that it will not breach the 10 session days. So that's one interpretation. But if there's a breach, that's a breach of the House rules. That's not a breach of the Constitution. We're looking at this, whether the Constitution was violated.
Very quickly, one last question. If the senator judges, one of them, 2 of them, or a number of them, a few of them raise the question on jurisdiction of the impeachment trial, whether the 20th Congress has jurisdiction over this, it goes to plenary, the senator, whether senator or senator judges vote and they get a majority vote, and the vote wins to dismiss the impeachment case. What do you think? Well, definitely, a lot of people were already saying that they'll bring this up to the Supreme Court. But what are your thoughts about that, sir?
Well, the Constitution says that once the articles of impeachment are received by the Senate, trial shall proceed forthwith. So there's no room for any motion to dismiss, because a motion to dismiss is not a trial. So, but that defense of lack of jurisdiction can be included in the answer. You don't have to ask for a separate hearing on that it should be decided ahead of the main case. So, that will be given clarity also by the Supreme Court. in this. I think that
Decision that they will make. Former Senior Associate Justice Antonio Carpio. Always a pleasure to have you, sir. Maraming salamat po sa inyong oras.
Thank you, Pinky, for having me again.
Thank you. That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.